So let us go with the discussion of life insurance. See, in a common parlance, if you to go what is life insurance is, of course it is again a contract of insurance which has been entered between the insurer and the insured. We generally say with this because all these days from all the part of discussion we were having to with, we spoke upon with the same thing. It also satisfies with all those terms of the contract, all those principles of contract is applied with as being a contract in itself. So for that reason we shall say it is a contract of insurance which has been entered between the parties, that is by both the insured and the insured. But on the other way, if you look with what is this life insurance business? See, business is, that is when I say life insurance business is something which is in effecting, where the company is effecting a contract of insurance upon the human life of a person or human life of an individual. That is what the company does with, the business does it. We have understood that. If a company were to carry a life insurance business, then it has no other weight for carrying except for the life insurance. It cannot carry any other business because one entity can carry only one form of insurance. Maybe in that you may have different forms. But if I am to take life, it is only life. If I am to take accident, it is only accident. If I am to take fire, I am to take only fire insurances and no other. So one entity should have a right to go only with one kind of insurance. So being a life insurance business, what does the company do is that company would be effecting a policy on that of the life of a human being. That's what the policy does with. That's what the company does with. So life insurance is something, my friends, it is a policy drawn in respect of any human life. We shall say generally to save it. It is a policy which has been drawn, or it is a contract which has been entered into in respect of taking up the risk of a person with his life. And if you read section 2 clause 11 of the Insurance Act 1938, it says any contract or in any contract wherein if a party agrees to pay, please undergo with each and every word, because see, when I am speaking this, sorry, I am lightly deviating myself. When I go with the definition, each word has a sense in itself. If you just take away that word from that part, maybe it could be has, is, it, was, may, shall, be. If you take away any of this word, it would change the entire meaning of its understanding. It may straight away put the other way of the understanding of it, which is not acceptable. So we should understand by each and every word of the definition what is being given to it. In that scenario, I am speaking this, my friends. That is, when you read section 2 clause 11 of 1938 Act, it says any contract wherein if one party agrees to pay the given sum of money upon the happening of the particular event, which is contingent. I repeat this is an important word, which is contingent upon the duration of the life, or that is human life. Where if the contingency is with the duration of human life, for that contingency, if you are paying certain amount of premium to the company, to that of the risk what you are taking in, then that is called as life insurance. So in a common parlance, by the definition we can understand in this way, my friends. It is a contract wherein the parties who have agreed to pay certain amount of consideration, and that consideration would form to be a premium of what you are going to pay upon the life insurance or upon that of the insurance policy, to the risk that if any particular event would happen, then the company would undertake that risk. That is, it all depends with the contingency of its duration of human life. That is the existence of human life. So what we can understand here is that, as I was very quite oftenly saying you with this, is that when it comes to life insurance, life of a person is always certain in its end. Everywhere we say that. We say that in Kannada, Uddam Sayode Ilva anta. We say this in Kannada while explaining with this. So when a person, as soon as he is born, the death is certain in him. The death is guaranteed. You cannot overcome, you cannot overtake the death, but the duration of which where the death comes in is the only question which is a subject of this. So where if the contingency is because the contingency is with respect to the duration of your existence, and for that duration the contract is going to be effected, and that is what we call it as life insurance, and that is what we call it as an insurance of contract under life insurance policy. So we in a common understanding, in a simple plainer language, if you to go with what a life insurance is, it is an agreement entered between the parties to give such sum of money on the happening of a particular event, and this is done in exchange of the consideration paid by you in the form of premium. That is what we call it as life insurance. And what are the nature and scope? First, let us look down to the nature of life insurance. See, when I say nature of life insurance, most of the features of nature of contract act, because again this is one of the contract, that is most of the nature of the insurance contract are also the nature of life insurance. And what are those? See, one hand we can make it like to some extent we can differ with this nature with other one. Like one is the life insurance contracts are unilateral contract. But whereas in other forms of contract, we see it is not an unilateral, it is bilateral in nature. Both the parties comes to the consensus together for having entering into a contract. But it is in case of this, it is an unilateral in nature. I'll explain to you how it is unilateral. See, when it comes to the enforceability of the promise what has been agreed upon, the company is fixed in its liability and says that as the company is liable to this extent. In this way, I can also put you across with. Suppose when I enter into a contract of life insurance and we have taken up the policy by paying the first premium of the policy, what is the effect of this? The contract comes into existence. When the contract comes into existence, the company cannot compel you to pay the money. The company cannot refuse you from accepting the money. Once when the contract has been concluded, suppose say if I have taken a policy for 20 years of my time. Once when I have taken the policy for 20 years of my time, the time where I have taken, when the policy might have been come up into existence, the proposal might have accepted, then once when it has been accepted, the companies say, no, that I'm going to repudiate your contract, I don't want to continue with you. It cannot say. That's where it becomes unilaterally. Suppose say in case of fire and marine insurance, you have a right to go. Today I enter into a contract and tomorrow you find that no, it is not good. The weather is not good. The ship is on voyage. I don't want to because the risk is more for me. I may go repudiate the contract with certain amount of penalty for it. But not in case of life insurance. This itself being a welfare policy. This itself is being a welfare scheme provided by the state, which is accepted by the state, which the state as a duty it is required to call upon, where it says that no, you cannot repudiate the contract after the contract has come into existence. You cannot stop. Suppose say I have taken for 20 years of my policy, then you cannot stop taking the premium from me. Of course, you may have an imposing of condition in taking the policy. That is, within this time to this time you have to pay the policy or you have to renew your policy. All those things are there. But you cannot stop from having not accepting the subsequent payment. So when insured pays the premium and if he continues to pay the premium regularly, then the contract is in existence. You cannot say that no, the contract has taken away unless where because of the default of the is insured there is a forfeiture or foreclosure of policy. Unless the act of law, under the terms of law, if it is brought down with, you cannot have a foreclosure of, you cannot have a foreclosure or forfeiture of policy. So that is the reason why it makes something different, which we call it as the insurance is unilateral policy. The second one is it is a conditional contract. Why I say it is a conditional contract is when I take an insurance of life policy, it is subject to the condition privileges provided on the back of the policy itself. Says that you have to pay this, you have to pay this. Maybe it might be with respect to the conditions of the policy. It might be with respect to the types of policy what I am holding with. And sometimes it may also be in the form of a condition precedent. Say for example like this. If I'm cross the age of 50 years, then if I'm to take a life insurance policy, maybe for 10 years or 15 years or so, the condition might be that you have to get a certification from the doctor regarding with your healthiness. And maybe after 50 years of time, you may also require to go for a medical report. The company can call for you for giving a medical report for each and every year on its renewal. And if that conditions are imposed in, then you have to comply with those conditions. You have to satisfy with those conditions. You cannot go above those conditions. So in a way we can say that this nature, it can also be a conditional contract. It is in a way we can say that is the insurance is a conditional contract. Then the third one is insurance is an aleatory contract. Why we call it as an aleatory? See, as soon as you take the word aleatory specifies to the chance, depending upon the chance of this particular thing. That is happening or non-happening of the event we say. It is just on the contingency we say. Why we say it is in contingency is that, see, the happening of an event may or may not take place. And what would this result in? This results in the exchange of the value of the happening and non-happening of the event. Why we also say it is aleatory in nature? Because for the reason that there is no exchange, mutual exchange for the value of what you have taken with. Suppose say in a fire insurance, because normally we vary with other forms of insurances. See, when I take a fire insurance policy, I know that I am liable to pay 20,000 as the policy, for which if I am going to incur a loss, the company is going to pay me 5 lakhs of rupees. I know this. So my payment of consideration is ascertained. Even the payment of the loss what I am going to incur in is also ascertained, subject to that of if the loss is very less. So I cannot exceed more than that or go less than that. But the payment is assured from my part. But when it comes to the life insurance policy, it is not the same. It is not the same, which says that it is quietly different from that of the other insurances. It's quietly different from that of the other insurances, which says that is when I take up the policy, it depends upon the contingency of my living. That is, if I am at the age of say 28 years or 30 years for that matter, I have taken the policy to the extent of 50 years of my time. If I have taken the policy for this number of years, see, as soon as the premium is being paid by me on the very first day itself, that is, premium is accepted, the proposal has been accepted, the policy has come into existence. Once when the policy has come into existence, maybe I might have paid per year, I might have paid 10,000 rupees. And the insurance contract is maybe for 20 years, it is 20 lakhs of rupees. I might have paid just 10,000. But once if I die on the very next day on the payment of this 10,000 rupees, sometimes even it could be where the payment of money is waived by the company, even I might not have paid that also. But when I have paid 10,000 and if I die tomorrow, the company becomes liable for me to this extent of 20 lakhs of rupees. So it is not fixed. See, where is the value you can consider in? Paying 10,000 and getting 20 lakhs of rupees. Or you may survive till the period of 10 years. By 10 years, you might have paid 1 lakh of rupees. Again, you would get the same amount. So, what I am trying to put you is that there is no exchange of the value that is equal value for what you are taking with. That makes the condition it as aleatory in nature. That is the reason why we say that where the occurrences or where the payment of premium depends on the occurrences, that is death, And even where if you have paid only less premium or few premiums of it, but you are entitled to the full amount of this. That makes an aleatory on the part of the company also. That is why we call life insurance is an aleatory contract. Now, the second thing is that what is the other features or other nature of it? See, the another nature is that this is a contract of adhesion. ADHESION. This is a contract of adhesion. Yes. See, why we call it as a contract of adhesion? See, this is not a contract which has come by way of negotiation. In fire insurance, okay, you pay me this, you would be going only in this, or provided I may say that no, I cannot go, you may give me a grace period of time, or you give me a grace period of in which I can go in a different way. All these things are there. All these are brought by the negotiation. The terms can be accepted mutually by the parties. The conditions can be imposed mutually by the parties. But in case of life insurance, it is not that. See, in case of life insurance, my friends, we shall see that there is no question of mutual negotiation. This is fixed. See, this is what I am going to do. You want this, you have this amount of premium. Suppose sometimes under the scheme, in fire insurance, they may reduce the premium level also. Suppose if it is not a rainy, if it is not a winter season, if it is not a time wherein the Deepavali is coming in case of fire insurance, then they may also reduce down the premium. But in life insurance, nothing as such. Nothing has such. There is no question of negotiation itself. The fixed, it is decided by the insurer, and the insurer, whatever that has been decided, if I accept that of deciding, I have no choice, either have to accept or quit of it. If I don't want to take, I can quit it, or if I want to take, I can proceed with. So that is what we can see in case of life insurance contract. That's what it makes the contract as an adhesion contract. There is no point or there is no question for you for the negotiation between the parties. There is no question. Of course, in the part of claim, if the claim is being disputed, then maybe you may enter into a compromise before the Lok Adalat or something, that is different. But when the contract itself, if you see, it is an adhesion contract. The fifth one is, it is a contract for certain amount. It is a contract for certain amount, as I was saying you here. See, when whatever the loss is there, see, if of course the eventuality is death here, death is there. So when it is a case of death, that is, it provides something, my friends, the amount is fixed. But whereas in this, when I was saying you, I paid 20,000 for 5 lakhs of rupees. Suppose if the loss is incurred just 25,000, the company is liable only for 25,000, not for 5 lakhs of rupees. So it is because all this are the contract of indemnity. Whatever the loss that has been there, that has been. But it is not the same thing here. It is something, my friends, it is for the certain amount. That is, the question of contingency in payment of the premium does not arise or does not, it is only on the happening of certain event, that is the death, and on death the company, whatever that you might have paid, whatever the number of installments that you have paid, but the company becomes liable. Maybe in addition to this, that company may go for you paying the bonus for the number of years what you have paid regularly. That is the amount for which of 20 lakhs. Maybe to that extent it may vary, but otherwise we shall see that the premium has been fixed by you by the company. So that is why we say that the contract is certain in its amount. And the sixth one is, we always see life insurance contracts are taken in the form of standard form contracts. Why I say standard form contract is that maybe the company would have followed or observed all those essentials of contract specified under the Indian Contracts Act, and it would have followed saying that the contract would not become a void contract, like all those offer acceptance, condition, what is consideration, free consent, lawful object, all this could be followed with. But in a way, it is not an agreement which you enter into. At the back of the thing, as I was saying you then, we see that the contract is already been decided by the insurer. That is, when I enter into a contract of life insurance, these are the things which are necessary. These are the conditions which are necessary. These are the particulars which are necessary. It is fixed. and you have to enter into a contract in that way. That is the reason why we say that life insurance contract is also a standard form of contract. It is a standard form of contract. So in this way, my friends, we can understand as to the nature of life insurance. And when it comes to the scope of life insurance, friends, the insurer is free to evolve the principles and conditions that he has with. He can evolve. That is, while having a standard form of contract, he may add certain condition to that, following all those general principles of contract or observing all those general principles of contract, he can go with. But only restraint here is that when he is imposing a condition, the condition what it requires is this: it should not be unconditional in nature. It should not be unlawful in nature. So subject to this, my friends, we shall see that the life insurer is free. That is the scope which has been given, not in case of other insurances. All these are made by mutual agreement. But in case of life insurance, we shall see that the policy, that is the insurer, shall have a policy maker shall always have a right to impose any such condition. And what is the duty on the part of the assured or the policy holder is that he should only see that, or he should only prove that in case of eventuality, he has to show the death that has caused. Prove the death, what is proving of the death, as how the death, whether it is by natural or by disasters or by accident or whatever, that he has to prove it. Only that of which other things are not there. Suppose, say, for an example like this, I would say, I have taken a life insurance policy, I am driving my motor vehicle, ration negligently, as a result, there is a death caused to me. Or maybe even without ration negligence. Now, what is that I am required to prove here? I have to prove that whether the death is by way of an accident or whether the death is by way of suicide. Then the company looks back, whether I had a lafda with my wife in the previous night, or whether I had a loss with my business structure. All these things would be looked in. So, only thing what I am to prove here is that the death has required under the contract. So, the material facts what I am looking to here is the death. The cause of action what we are looking to here is the death. And on the basis of that, the company is going to look upon, or the company is going to affect the policy or effect the policy. So this is how we see a little bit of the scope of the life insurance. And if you look at the features of life insurance, friends, quickly I'll go. See, in a way, life insurance is being effected only on the human being, or it is a contract relating to the human being, we have understood it. Apart of this, my friends, here the feature is that insured undertakes or agrees to pay the premium periodically. It is not a contract of indemnity as we have understood. That is life insurance. That is where how it makes a difference from that of other contracts, as I was saying to you. The presence of insurable interest is necessary. Investment is in the form of saving. So also, my friends, it is always connected to that of the human life, as I then said, sorry for that. And it is a cooperative device which has been amicably made among ourselves. It cannot said to have an express provision for other than that of the money on death. We cannot have other than that, and the payment could be in the form of lump sum. So these are some of the features of what an insurance is. Now, quickly having understood what a life insurance is, let us also understand how does it differs from that of the other insurances. Friends, when it comes to the life insurance, we have understood that just now in our discussion we have come to know that is life insurance is going to be effected for the human life. Except of human life, nothing is there in the life insurance. Nothing is there. That is, I would take the insurance for my death. That is for the uncertainty of my death. That is, it is clear on that. And the basic difference that you can see here is that though I am taking an insurance for my life, this life may not have an economic value. I don't say I don't have a value. I may having a value. I'm not in that line. I'm saying that I cannot take or I cannot ascertain what is the value of mine. So I'm just saying you in this way that when I take an insurance policy, life insurance policy, I may not have an exact economic value. but only the value is being judiciously decided upon with. That is, of course, in the terms of money. Suppose, say, if somebody comes and asks you that, what is your sufferings, what amount of sufferings that you have incurred in on the death of your father? Can you explain that? Can I say this is the amount for 100 rupees or 1000 rupees or 1 lakh of rupees I had incurred the agony because of the death of my father or my grandfather? Can I say with this? Definitely not. Because that is not valued in the terms of money. It cannot equate in the terms of money. And the money might be the factor there. The consideration could be made in the terms of money, but that money is being judiciously recognized with, judiciously valued out with. That is the difference, basic difference we can see. But when it comes to the fire, marine or accidental or burglary insurance, in all these kinds of insurances, we see that death is not a factor there. Maybe sometimes, but death is not a factor there. But how is it determined? It is on the value of money, because all those are the contracts of indemnity. Any loss that you have taken in, for that loss of amount you are going to be paying upon with. So that is what is we can see. And even in respect of payment, my friends, we shall see, in cases of life insurance, as I also then spoken to you with, the payment is certain. Whatever that is being payable by the insurer to the insured is certain in its event. But when it comes to the other insurances, it is not certain. Depends upon what is the amount of loss that you have incurred in. So these factors could be some differences. But apart of this is the basic difference I'm speaking to you. Apart of this, my friends, we have other differences to be made out in this. The other differences are like, suppose, say, in case of loss. See, in case of loss, the company becomes liable. But how is this loss ascertained? Do I require to have a proof of loss that is being caused? Of course, to smaller extent, I can say death was not caused by way of the suicide. Maybe within the span of time. Of course, we have a relief of this also. That is, death has occurred. Only proof I have to show is that death has caused. How death has caused, whether it is by way of accident, unless it has been prohibited by law or by the terms of contract I am speaking, death has to be explained, death has to be proved before the court. But how death has caused, whether by natural death or whether by death because of old age, or whether the death is because of an accident, or whether the death is by of suicide after the term is being expired, these things I am not required to explain upon with. So the proof of loss is not required there. Even without a proof of loss, except that of the death, the company can go for your honor. That is, it can take the indemnify, or it can compensate. Sorry for taking the word indemnify. It can compensate you for this. But when it comes to the other forms of contracts, it is purely a contract of indemnity. So when it is a contract of indemnity, you have to establish a proof of loss there. You have to establish what is the amount of loss. Whether my loss is for 10 lakhs rupees, 5,000, 5 rupees, 5 lakhs, 50 lakhs, or so on and so forth. I have to establish. So proof of loss is very much required in all other forms of insurances. This is one difference. The second difference is this, my friends. See, in case of life insurance, as we have understood even prior to this also, event is certain. Maybe sooner or later, event is certain on this part. Death is certain sooner or later. But what is going to be decided there is that when the death comes in, this is the only question where we are going to. That is, because of this uncertainty, we are going to take life insurance. But when it comes to the other forms of insurances, the entire insurances is on the contingency. Whether that is at the time of what I have taken the insurances, whether the occurrences would happen or not. Because the occurrences may or may not happen in itself. May not happen in itself. So that is one another differences we can make out between these two areas. The third factor we shall see is that with respect to the insurable interest. When it comes to the insurable interest, my friends, we have already also again understood. Only thing is we have to remember back and put in a place now when it is asked with. When I was speaking to insurable interest, I was saying when insurable interest should exist in each kind of policies. When a life insurance policy is there, then insurable interest should be at the very beginning itself. At the time of entering into a contract, the insurable interest should be there. Later on, it is not necessary. Later part of days, it is not necessary. When today I might be an husband and wife, that is, I might be a married man and I might be having a good relation with my wife and me. But tomorrow, very next day, I may lose out. I may lose out the interest. We may get depart with each other. We may take a divorce of it. But still the insurable interest is there on my part. But what insurable interest calls in case of life insurance, on the day of which you are taking the policy, you are effecting the policy, on that day there should be an insurable interest. But in all other cases, fire insurances, in case of fire insurance, you should have an insurable interest even at the time of effecting the policy, and also it should be continuous till the discharge of policy has been made. But in case of marine insurance, when the policy is whether you have an insurable interest in the beginning or not is immaterial, or it is continuation is immaterial, but at the time of you discharging the policy, you should show your insurable interest. So this is how we make a differences between. And one another important difference which I have not spoken to you for all these days is the wear and tear, inherent vice we call. Inherent vice or wear and tear. See, this body, maybe for another, I may not have retained the same strength, the same energy, the same health what I was there 20 years back or 25 years back when I joined to this profession. Now, I may have lost my weight, I may have lost my health, I lost my days, that is the number of years. So, when it comes to the usage of my life, I might have exhausted my wear and tear of my body, inherent vice of my body. But will that have a depreciation in the payment of your compensation? No. That is what in life insurance is looked in. So, inherent vice or wear and tear in that of a policy are not a matter of concern in life insurance, or not a matter of concern of life insurance. But when it comes to fire and marine insurance, we shall see that is, suppose say I take a motor vehicle policy, wear and tear is taken away, depreciation is being charged there. So that makes a difference between these two. And likewise, my friends, the another difference is that again with the same insurable interest. Insurable interest is capable of being valid in case of life insurances. But in cases of other insurances, you do not have to. Insurable interest need not have to be capable of valued with. What is insurable interest need not have to be valued with. Even in case of assignment I am speaking with. Likewise, the last difference we can make out between the other forms of insurance is that in case of life insurance, it could be a contract for whole life of insurance, or it could be for a sufficient long period. I was giving you an example for 20 years of time. But in cases of other insurances, usually, my friends, it is for a shorter time. Maybe from one voyage to the another voyage, or it could be from one place destination, you might be fixed from one place. After reaching, you may go out, or usually it is in a short form from year to year. So in this way, we shall see that insurances are differing from that of other insurances. And what are the advantage of this life insurance? Having understood the differences, like how it differs from the other policies or like other insurances, like what is the advantage? Quickly, I don't take much of time because most of this I have also discussed to you in my previous slide. Just to make you understand like what is to be written here, I'm just explaining to you with all these things. One is, it is a superior saving plan, I can say, my friends. Why I say I'm taking the word superior here for the reason this, my friends. See, it is something, an investment plan that I'm making to go with. I'm making with. And out of this investment plan, I'm saying it is superior for just for the reason of this. Like, if I'm taking an RD, or if I'm making a recurring deposit, or if I'm making my saving deposit, what is that I'm going to do? Hardly I'm going to get an interest on it, is it? Or in recurring deposit, the two with certain schemes, I'm going to get a compound interest. Is that right? But this is not the same. See, what am I entitled to? By me making a deposit in this, it is a kind of a saving plan. That is why I said it is a superior saving plan from other forms of investment. Of what you should decide and you should judge upon with. I don't know. But what I can say is this. Why I say it is a superior plan is that, see, you have a compound interest payable on that of the insurance you are paying. You have a bonus to be paid on that. Company, if in a bank, they would not give you a bonus if they have a good profit in you. Is that right? or you are also in fact entitled to a form of security. You are entitled to a form of security. Why I say it is entitled to a form of security? Suppose tomorrow, if you draw your RD, what happens? I may open my RD in a bank, and having opened a recurring deposit, what I may do? I feel that okay, this month I am good enough to pay. Second month I am good enough to pay. Third month or fourth month, I may feel lazy going to the bank. Of course, online payment is there now. That is a different issue. But I may have a money in third month. Maybe if this continues for 2 months, I may foreclose that. Because I have an option. But in case of life insurance, no. The reason is that if you have taken for 3 years of time, or you have paid 5 years of your time, and having paid this for 5 years of time, if you want to foreclose, no, that is not. Of course, you have a surrender of thing, but it is not freely allowed to you. You would lose the money. So once when you lose the money, what is the sense says that, okay, let me wait. Maybe 4th month, 5th month, you cannot pay. In the 15th year on its maturity, you would be entitled to, along with the interest and bonus, what is that is to be added to the payment of what you have made. So that is the reason why we shall say that it is a form of a superior saving plan which you can have in. This is the first advantage. The second advantage is that it encourages you from the forced thrift. That is pre-closures, like what I was saying to you. It encourages you from the forced thrift of the policy, because it will not allow you. There is a lock-in period. See, any insurance policy if you are taken, it should be, that is a special life insurance, it has to be paid for the 3 consecutive years. If you don't pay, or if one premium is being paid, you lose the money. So what I do, the tendency pulls me up to pay at least for 3 years and then go for surrender of my policy, so that I can get the bonus also. So in a way, it is a part of saving itself. It is a protection to that of the creditors quickly. It is a protection to that of the creditors. And it is also suitable for you for raising the loan from out of it. More of than this, my friends, when I take LIC policy, every employee, more particularly I'm speaking, every employee, of course, others are also doing this, but still, majority of the employees, I can say 99% of the employees does this. That is the reason why I'm taking the employee here. The employee who is having a regular source of income would always definitely go for life insurance, because it is a super tax saving plan. It is a super tax saving plan wherein you can have, because under Income Tax Act, we shall see that how tax planning can be made, and one way of tax planning is this, that is investing in LIC. Or we can also say that it is an investment element. We can also say that it reduces you from all those financial burdens. So in this way, my friends, we shall see it serves you an advantage of this. And what is the procedure for taking life insurance plan? First, you would select the plan and fill up the insurance policy. That is, while filling up the insurance policy, you would be stating what is your name, nationality, age, employment, terms of insurance, sum assured, all these things, etc. Blah, blah, blah. All those etc. will be there. Premium details, etc. will be there. So you would be filling up those. A part of this, medical examination would be given. Agent's confidence report would also be given if it is being made through an agent. Acceptance of proposal would be in there. Proof of age can be also caused. Payment of premium will be made. Commencement of risk is there, and issuing of policy is there. This is how the procedure goes for an thing. But what is concerned for me here is this. What are the risks that is not covered under the policy? See, when you go down to the books, friends, you would come across as an exception here. That is, one, the premium is being paid. I was saying you it is a conditional contract. It is one-sided. The company cannot refuse you from accepting the premium once when the policy is being brought into force. It is unilateral in nature. So what are the exceptions we can say? The exception we can generally look upon is that is, if the person survives, then the survival money is being paid. But if the person dies on his own hand, that is what we call it as, if he commits suicide, then the company is not liable, maybe for a particular period of time. So except of this is an exception we can say in respect of life insurance policy. But apart of this, we have to go a little more further and look. Usually when the company would refuse you from the payment of this money, see, there are certain circumstances where the company is going to refuse you from the payment of money. That is, what risks that are not covered under the life insurance. death caused by the disease of AIDS. I repeat this, sorry for taking this word, but still, death caused by the disease of AIDS. Death caused by you becoming a drug addict, but by intake of usage of drugs. I'm not speaking medical drugs, I'm speaking. That is unlawful drugs, by usage of drugs. Death caused by skydiving in sports event. Death caused by skydiving. Death caused during pregnancy unless where the company has conditionally accepted for this. Death caused in pregnancy. Death caused by natural calamities unless where it is otherwise accepted by the company. Death caused by natural calamities. Death caused by the murder committed by the nominee himself. I repeat, death caused by the murder from nominee himself, or where if it is a case of suicide, then within 1 year from the commencement of policy. In all these cases, my friends, we shall see that life insurance policy is not affected. The risk is not undertaken by the company, and the company will not be liable for such amount of losses which you are going to incur in because of these reasons. So these are the exception where company becomes liable, not liable to pay you the money. So this is one way we can see that how the life insurance is going to be affected and how far it is going to be made. And what are the types of risk? Quickly I'll go. See, the basic division between life insurance and this other forms of insurances are, when you take the basic types of life insurances, friends, we can see term insurance and whole life insurance. These are the two basic plan we have in. Two basic plan. Of course, about this we have several things. What is term plan? That is, it is existing only during the term of policy, that is for a particular period. That is, in case of that particular period, if a person dies, then during that term, if he has paid the premium regularly, then the company becomes liable and you are entitled to claim the benefit. So, if I have taken a policy for 20 years, that is the term plan. I have taken the policy, and if the insured survives, the insurance is payable to the survivor, but if the insured dies, then to the dependents of the insurer or to the nominee of the insurer, the payment will be made. This is what we call it as term life policy. We have another one called as whole life policy. These are the basic two policies we have. Whole life policies is something where insurance is effected for the entire life of the insured person. Like usually, of course, when I say entire life of the insurance person, it is not something till his death, it is not that. There is also a fixation maybe for 60 years, 70 years, 80 years. But generally to speak with, it is till death. So this is something, my friends, where it is quietly different from the term insurances, because it also includes the term insurances plus that of the entire lifespan of a person. And in these cases, my friends, we pay the premium. The premium what is going to be made on this is quietly high comparing to that of term policies. So these are the basic two kinds of policies we can come across with. But apart of this, I don't want to take much of my time in discussing this topic, but I'll just mention you out with this. What are the plans that you can come in here is that joint life policies can be taken, annuity policies can be taken. A beautiful example I can give you for annuity policies is your money back policy. That is you pay to a certain amount, you get back the amount immediately. You pay for 5 years, you get back for 5 years. Or the policy might be for 20 years, but you get back the money. So annuity policies are there. Children endowment policy is there. Likewise, even endowment policy for elders are there. ULIP is there, ULIP, that is unit linked insurance plan, we call it as, where it is being invested in the market, mutual funds or share markets, and where from out of that is there, the risk is more on that in your part. We also have a factor called as group insurances, more particularly specified to that of medical insurances which a person could take in. And otherwise than this, we also have a Janata policy. We call it as micro policies, in fact, Janata policies. I think this has got its boost after the Honorable Prime Minister Narendra Modi had come up with this concept more popularly. Of course, he did not bring, but still, he boosted upon with this policy, that is Janata policy. That is where in this kind of policy, the premium is very low. That is, it is just made to cater the lower class of people, and the compensation, the premium is very low, maybe a very meager amount like 50 rupees, 200 rupees or 200 rupees or so. And the compensation is payable on that, and also the compensation will be very less. But when you compare to the premium, when it compared to the premium what you are paying, the compensation. Say for example, for the payment of 50 rupees, you will be covered to an extent of 2 lakhs of rupees of your coverage. So in that way, if they are provided with that, we call it as Janata policies or micro policies we call it as. So these kinds of types of insurances we come in. Again, quickly, because most of the discussions we have made, I'll just go with the other part of it. When contract is complete in life insurance, generally we say, yesterday also, in the previous slide discussion, we were speaking to you with the premium. I was mentioning you about all these things. See how premium comes into existence by mutual consent of the parties. That is proposal and acceptance. On the basis of this, the policy comes into existence or the contract comes into existence. But what is the necessary factor to see that the policy is complete, the policy is effected with? See, first the proposer has to tender his offer and pay the first premium on it along with the proposal. Then if his offer is being accepted by the company, then the policy comes into existence or policy comes into existence. Sometimes it so happens that there might be a requirement of correspondence. I might have paid the first premium also, but it may call for certain correspondence. Say for example, the company comes by your verification of your proposal that you need a medical examination and calls you to file a medical report. It might have honored it, it might have taken the money from you, but till the correspondence is being satisfied with, the premium has not said to be made, the proposal is not said to be accepted with. So there we have to see that the payment of having been made to the company itself is not an acceptance, but until and unless where the correspondence or other side criteria is being satisfied. But generally to speak with my friends, on the payment of first premium, we shall say the contract is to be concluded with. But who can accept with this? I would like to bring you one information here, my friends. See, when you go with an insurance policy and pay the premium on it, the person to whom you are paying should be capable of accepting it. If a person is not capable of accepting, or if he is not been authorized to accept, unlike in company law we speak ultra virus. So if a person is not capable, suppose say a divisional superintendent of an insurance company is not authorized to accept your premium. If he accepts, then no, he cannot be entitled to. It is said that it is not an acceptance. So if you pay money to an ostensible owner or ostensible authority, instead of saying owner, sorry for that, an ostensible authority, we say that the premium is not paid and the contract is not binding upon the insurer. So it is also at the same time equally necessary that to have an offer apart of paying your premium, it should be also being made to a person who has a power of accepting it. Or if there is also a delay in acceptance made, then also the offer is not complete. The acceptance cannot be said to have been made. So these factors we have to see here in accepting that of your premium. And sometimes it may so happen that in order to have certain verification and the report of the head office for the branch officers of the company may keep your proposal form in suspense. Then also it is not an acceptance, because on any of these areas the problem 9 question could be asked. That is the reason why I am repeatedly saying this. That is, if your account is being kept in suspense, then also it is not a valid acceptance, my friends. So in this way we see that the acceptance, but subject to this restriction, you can say that the premium has come into. But generally again I am speaking on the first payment of premium or on the acceptance of the first payment of premium, we shall say that the policy has come into existence. Then comes to the lapse of policy. Quickly with the lapse of policy. What is lapse of policy in the life insurance is that non-payment of due by you would lead down to the lapse of policy, or where there is a non-payment even after the grace period of time given by the company, then it is a lapse of policy. And in case of lapse of insurance policy, the company may refuse you to receive the policy itself, or if under the scheme it provides you for revival of this policy, it can go for the revival of this policy also. Usually there is as I then said in my previous video discussion, is that in case of a LIC, for a month it gives 15 days, for an half year it gives 1 month, 15 days, for quarterly and half yearly it gives 15 days, and for yearly payment they may give you 30 days of grace. So in this way the payment can be made, and even till the date of grace the policy continues with, the policy goes with That is, if the death occurred within the grace period of time, the policy is still in existence. The policy will be still in force, and the policy nominee or the person who happens to have a claim of right would also entitled to that of the policy. But only thing is that the premium should be paid within the grace period of time. And another important thing which I have to make a mentioning here is this, my friends. The lapse of the policy can be revived where if it in the lifetime of the policy holder, I repeat this, I want to mention this, where if there is a lapse of policy, that is your life insurance policy, this life insurance policy can be revived within the lifetime of a person, or that is of the policy holder, or sooner or later within 5 years of time, where if the policy is just paid with one premium. This is what I want to mention here. See, if you have paid the first premium and if you have failed to further go with the policy, it is either during the lifetime of yours or best within the period of 5 years as that the company has fixed in, whichever is lesser as the company fixes in. Within this time you have to have a right, or you have a right of revival of policy. That is only where the first premium is being paid. But in all other cases, where if the subsequent premium lapses with, that is you have paid 2 or 3 or 10 or 12 or 20 or 30, whatever it is, when it comes to the subsequent payment of policy, and if you have not paid the premium, then the premium will not lapse. That is, premium gets lapsed after the period of this time, and the company shall have a right to give you a right of revival under the scheme, and it can go for any number of years. That is, by prescribing the penalty, it can go for any number of years. I would go with one another interesting case here, especially with respect to the payment of premium. Of course, I thought of having discussing in my previous audio discussion, but I felt it is up to discuss at this stage. That is in case of Chatterjee versus Union of India, AIR 2002, my friends. That is in this case of Chatterjee, it so happened that Hashud met with an accident. As a result of this accident, immediately after the accident, he went into the coma. Having went into the coma, and this coma, during the period of his coma, his medication continued with, and before he could come out of the coma, he died. Maybe for 6 months or 1 year or so, he was under the coma and he died. Later on, the question came up before the court was this: whether the insured has failed in paying the premium within the grace period of time. Whether there was a lapse in payment of the premium which is liable to be made. The matter, of course, because on the death, the claimant comes before the company seeking for the claim, and there the court said that, yes, you cannot expect the same thing in the same as were in the other cases, and said that, see, the future payment of premium stands to be waived, or it stood to be waived during the continuous disability on the part of the person where he was unable to become liable to pay the money. So in that case, it said that no, is not liable. So in this sense, my friends, we shall see that the payment of premium also have small exception, but otherwise it says this. Otherwise it says that yes, the payment shall be made within the days of grace. The another important issue we shall see is the suicide pact in life insurances. Quickly, that is what we call it as fellow days say. In India, we all know this. You would have also read under IPC. The attempt to commit suicide is a crime, but suicide itself is not a crime. Important. It could be also asked in the objective forms of questions. I repeat this. In India, an attempt to commit suicide is unlawful. It is a sin. It is not legal in nature, but suicide itself is not a crime in India. If you have committed suicide, if you have already suicided with, if life is no more, then it is not a crime, because no one can punish you because you are not in existence. The same has also in England, my friends. In England, suicide is a felony. They also consider, no, it is not good. Even if you take the Shastras of us, Dharma Shastras, religious laws, suicide is wrong for us. But when suicide is a crime, when suicide stands to be a crime, then the company can deny the right of you claiming the money. That's what it said. See, very interesting case. In North Indian Assurance Company versus Kanaya Lal. In this case, it so happened like a contract was taken place for a life insurance policy, and the contractor have said this, that the contract would become void that if the insured dies of his own hand. Accordingly, Mr. Moolchand takes the insurance, and within 1 year transfers the insurance to his son. That is, he assigns the policy to his son. And in the 13th month of having taken the policy, he commits suicide because of having coming to know the fidelity, that is infidelity of his wife. He takes poison and he dies, coming to know with the infidelity of his wife character. Now the question comes up before the court is that, should the company be liable for this suicide? Because just after the assignment of 3 years or so, he dies. That is, in the 13th month, he dies as when he takes up the insurance policy. The assignee's son comes up before the court for the sum assured. The company denies for the same. He goes before the court. There the court says that has the commission of crime, the suicide itself is not a crime in India. That is, of course, it is punishable. But it held that committing suicide is not a crime in itself. It is not just a crime in itself. See, when you cannot give is where if the act itself becomes a crime. Where act in itself is a crime. But where the commission of suicide is not a crime, and especially by the rules of the life insurances we take in, as it is not a crime, or you cannot have a presumption of crime there, that is, after a certain period of time, it held that Kanaya Lal is entitled to the claim of policy. So in this way, my friends, we shall see that, that is, whenever when the question comes of suicide, it is said, however, the limitation is there now. Every insurance policy is that. Even the Insurance Act has come up. IRDA has also come up with this, saying that the presumption of proving to show that the suicide was not because of, suicide is not a crime, it depends upon the person. And where if the suicide is committed within 1 year of time, the company can deny the liability on its part. So this is how, my friends, we shall see how life insurance can be made. And so also, my friends, what are the losses covered is natural death, death of an insured person, and if it is by an accident. So here in all these 3 cases, my friends, we shall see that what is the proximate cause. An interesting case I'll go you, 2 interesting cases I'll want to go you with, and I'll conclude my discussion here for today. That is, one is Ambala Lal Lalubai Pranchal versus LIC of India. A very interesting case. I repeat this, Ambala Lal Lalubai Panchal versus LIC of India. In this case, the court held that in fact the plain petition was being made before the court because of the death of a person which was died because of the rabies that was infected when he was going on the way. This was an accident case. Whether the dog bite comes within the ambit of the scope of accident was the question before the court. See, it was so happened that when a person was walking on his way, that is during his walking time, a dog bites to him. As a result of this, he was infected with the rabies. And that turned out into be an outward act on his body, violent, and he lost with all those senses. So it died from that of the act of rabies. The question came up before the court was that whether this could be considered as an accident. And if it is an accident, then he is entitled to a compensation under the policy. So there, the court going through it said that as the company is liable because the death was found by an accident, as the act was outward by the dog, it was violent in nature, and also there was invisible means of having looking that there was no negligence on his part. So these factors gave to consider the court that yes, it is an accident and the company is liable. So this is one case. And another interesting case, a Babri Masjid case I'm speaking to with, that is Mrs. Veera Arohara versus LIC of India 2006 case. See, the deceased was the member of the group who had been gone to the demolition of Babri Masjid. There was a call given by Hindu Seva Sangha and all other organizations. So several peoples had gone there, and On the call, even this Veera Harohara had also been joined with the group, went in for the demolition of this group, and the demolition was taking place. In fact, the curfew was imposed there. In spite of the curfew, demolition had taken place. Demolition was carried with. As a resultant of this, the company, the police authorities was required to force a fire on some of the, that is in the air. And when the fire was opened, one bullet shot this Veer Arhora and it died. As a result, as he was protected with an insurance, he had taken an insurance, his wife, Mrs. Veera Arhora, came before the company for honoring and said that there was a death. The death was because of an accident, and because there was no intention of firing on the person, but still the firing has taken, and because he was in the way, it was got into and he died. So he should be brought under the ambit of accident and the compensation has to be given. The court going through, of course, the company denied of pay. The court going through this, it said that there was a curfew imposed by the state, and even in respect of curfew, the police, that is the authorities, have ignored in having looking into the very act itself is not evil, that is, it is not available for the protection under the law, and as such it said that the death was certainly does not fall within the ambit of accident, and the benefit cannot be made available to that of the deceased wife. So in this way, my friends, it is closely looked in, that is, if your death is because of an accident, then you are entitled. So what are they discovered is natural cause, death by an insured person, and even by the accident. And how assignment is there? Just now I have spoken to you with assignment shall be made in terms of the policy, as in a previous slide I have discussed. There should be a policy, there should be an endorsement, that is, there can be an endorsement on the back of the policy itself, or where if it is in a separate sheet, you can make it and as endorsement can be made. That is, while endorsing, you should give the bond, KYC details has to be filled in, and proper form has to be filed. In this way, my friends, you can see that assignment can be made. So this is, my friends, has what a life insurance you should understand very briefly from the point of your examination. So in this way, you have to, taking all this as a consideration, you should go, and this is what we can see as what is the nature, what is the scope, what is the future, how does it differ from, and how insurance contract is elected, and how the policy is looked.